The ongoing debate over super PAC donations in Maine played out in a federal appeals court today.
The case stems from a 2024 ballot measure when nearly 75% of Mainers voted to place limits on contributions to these super political action committees. They spend money on specifically advocating for one candidate or the defeat of another. The measure was later struck down by a U.S. district court for violating the First Amendment, ruling contributions to super PACs don't need to be limited to avoid corruption because it is already illegal for PACs to coordinate directly with candidates. Well, today, attorneys appealing the ruling argued the majority of super PACs today still are unfairly aligned with specific candidates, even if they are not communicating directly. Opponents, however, argue that corruption can only happen if the super PACs are specifically breaking that law.
There doesn't have to be a prearrangement or an agreement or any kind of communication at all between the candidate and the donor. The contribution itself is enough to create the potential appearance and reality of quid pro quo corruption.
There is disclosure of donations to super PAC expenditures, so that's out there. And there is no ability to coordinate whatsoever.
If the court accepts the appeal, the case will continue to the Supreme Court and could potentially impact the 2028 election.